Good morning, good evening, hello. My name is Luke McNamara, and it is my great pleasure to open proceedings for the 2021 UNSW Centre for Crime, Law and Justice annual lecture. I'd like to begin by inviting Auntie Lola Ryan to give the welcome to country.
Oh, good morning, everyone. My name is Auntie Lola. I'm from the La Perouse Aboriginal community on the shores of Botany Bay, and I belong to the Dharawal language group. I would like to start by acknowledging the traditional custodians of the lands where you all are meeting or coming from, and pay my respects to all elders, past, present, and emerging. I'd like to extend that respect to all Aboriginal and Torres Strait Islander people who will be present here today. It's my pleasure and a great honour to be here to welcome you all to the UNSW Centre for Crime, Law and Justice annual lecture for 2021. Traditionally, our people would welcome other tribes through their land and have a ceremony that informs them of resources such as food and water. Rock carvings, paintings, and animal tracks would let them know the kinds of resources that are available in that particular area. Today, we welcome all Australians and other people from other countries to our country on behalf of our ancestors and our people. We had an oral language and would communicate through storytelling, song, and dance and art, as there are many Aboriginal languages throughout Australia. We still use those methods for storytelling, song, dance, and art in a traditional and contemporary way to teach our children their culture and to be sure it is still thriving for generations to come. Our people and culture have survived for over 60,000 years and is one of the oldest living cultures in the world and will survive for many more. I'd like to say today is Remembrance Day for all our soldiers all over who fought for a peaceful world that we live in, lest we forget. On behalf of the La Perouse Local Aboriginal Land Council, my ancestors, my people, I wish you a warm welcome and hope that you enjoy your lecture today. Thank you very much for having me. Sorry I can't stay with your meeting, but I have other commitments. Thank you very much. Enjoy your day. Thank you.
Thank you, Auntie Lola. Thank you very much. Now, before I introduce our speaker for today's lecture, I want to acknowledge the many colleagues who are the present Centre for Crime, Law and Justice. But I also want to acknowledge the many scholars who, for decades, indeed for the entire 50-year history of the UNSW Faculty of Law and Justice, have pursued social justice and change-oriented criminal justice research, teaching, and activism. It's a fine tradition, and it's one that the Centre is really determined to continue. Professor Kelly Hannah-Moffat is a professor in criminology and socio-legal studies at the University of Toronto, where she's also Vice President, People Strategy, Equity and Culture. For many years, scholars around the world, as well as policymakers and reform advocates, have benefited from her outstanding interdisciplinary scholarship. We are delighted that Professor Hannah-Moffat accepted our invitation to deliver the 2021 Centre for Crime, Law and Justice annual lecture on predictive analytics, risk and legal inequalities. Now, there will be a Q&A opportunity at the end of the lecture. We invite you to post questions in the chat function in this meeting during the course of the lecture. Feel free to use the chat to make observations, but also to post questions, and then we'll draw on those questions at the end of the lecture for the Q&A. So, Kelly Hannah-Moffat, over to you.
Thank you very much. Just before I start the PowerPoint, I just want to thank you for the invitation and thank you for having me here today. I very much wish that I was there in person with you, but nonetheless, Zoom will have to do. But that does mean that I am speaking to you from the land on which the University of Toronto operates. And for thousands of years, that has been the traditional land of the Huron-Wendat and the Seneca, as well as the Mississaugas of the Credit. And today it is the meeting place and still the home for many Indigenous people across Turtle Island. And I am very grateful to have the opportunity to work and live on this land as a guest. So with that, I also, before I begin, would like to acknowledge that much of the work that is being presented here today is a collaboration with the postdoctoral fellow, Kelsey Barkway. And so with that, I think I shall start. So today I wanted to have a talk that could cover off a number of different kinds of issues in different segments of the criminal justice field, and hopefully have some appetizers that would appeal to many of you who are here today. And in the talk, I want to start to raise some critical questions. I don't have answers to them, but I will raise the questions. And I want to sort of talk about the issues around algorithms and digital transformation. So we know that for several decades, the criminal justice systems have been going through various forms of digital transformation. This is not new, but we are in another phase of it. Technology has become increasingly sophisticated, and there are several scholars that have examined police agencies' use of biodata, facial recognition software, traffic cameras, body and car cameras, license plate readers, and global positioning systems, all of which produce digital data, and they can be combined to identify and track individuals in the pursuit of security and safety. Private companies are starting to market and distribute data-driven technologies to legal professionals and also to criminal justice institutions. And it's critical for us to start to examine the social, political, and legal, as well as the institutional context in which these technologies are deployed. AI algorithms produced for justice are not just merely sets of rules and software, nor are they mathematical objects. Instead, as Jeffrey notes, they are artifacts of governance designed to achieve very specific objectives. And as such, the emphasis of analysis ought to include thinking about the logics and rationalities that are informing various forms of AI, or artificial intelligence, or machine learning, and how these logics are going to merge with the institutional logics of various legal and criminal justice institutions. After all, these technologies are built to facilitate the governance of crime and legal subjects. And I want to argue that the use of algorithmic technologies in criminal justice processes produce new forms of knowledge that coexist, absorb, and alter pre-existing techniques of governing, while simultaneously reinforcing structures of inequality. Their adoption is highly contingent on their compatibility with organizational objectives and the problems of the day. Patterns of both legal and penal governance are messy. They often reflect a combination of fragmented and flexible forms of power that interdependently coexist with various forms of knowledge and logics. Sophisticated forms of AI and machine learning are being developed, legitimated, and used in our wider political and social contexts of legal efficacy, and also in terms of the call for accountable and ethical governance. Recent academic scholarship has framed these technologies as algorithms of oppression or as weapons of mass destruction. They've also talked about the human biases that are embedded in these technologies and at every stage of their development, use, and then long-term impacts. Now, notwithstanding these critiques and the very detailed and sophisticated scholarship that traces and deconstructs a number of algorithmic technologies, I want to talk about the shift in focus by showing how these technologies are differently constituted and how they produce inequalities of data harms that challenge the integrity of our legal systems, and how these very technologies are then being used and reconfigured as solutions to the above-mentioned problems of bias, racial discrimination, over-policing of Black and Indigenous individuals and communities. thus risking what I feel is further entrenchment of the existing inequalities in the status quo. So in this talk, we show how the choices of when and where to use algorithmic technologies, the problems they are used to solve and are bound up with, are linked to deep-seated organizational logics and institutional practices for managing crime. Now, rather than meticulously mapping the unfolding of technologies, I will situate and examine how three forms of algorithmic governance coexist and function interdependently with past forms of governing. The arguments that I'll make here are built on some of the insightful work of scholars like Schoenberg and Peters, who recently produced an edited collection on the complexities of algorithmic societies, the succinct analysis of the digital sociologist Paul Herman, and some of the pioneering work of Janet Chan and Larry Bennett Moses, Pat O'Malley and Gavin Smith, and many others who started to query and think about big data, algorithms, and machine learning. Now, although I'm going to talk about how algorithms expand the possibilities of crime control and shift legal cultures, it would be important for me to note that there's a plurality of subfields within this term algorithm or machine learning or AI. So throughout the talk, please note that I do understand that there's very detailed differences within these technologies, but I will use the terms artificial intelligence and machine learning and algorithmic practices somewhat interchangeably. The paper is also looking at the rationalities and practices of the developers in three areas of criminology and law. One is location-based police technologies and risk algorithms. The next is risk algorithms developed by psychologists and basically looking for solutions to determine recidivism. And then the third is legal software. And I want to look at how these technologies are being rebranded and how they're being marketed as bias-free and ethically neutral instruments that can be used to enhance police accountability and legal work. Now, as a caveat, I will say I am by no means a substantive expert on legal work or policing. I do know a little bit about risk, but I am deliberately using these examples to make some wider points about the flexibility and fluidity of algorithmic logics and technologies to show how they evolve, how they pivot, and how they assemble with different forms of governance while simultaneously reproducing structural inequality. And I also argue that the algorithmic solutions that I want to talk about are diverting us away from some of the more fundamental questions about how technology might be used to consider how justice can be done differently. So my first example will be predictive policing. So although there are areas of the criminal justice system that have incorporated actuarial logics as early as the 1920s, in policing, the shift to predictive technologies has occurred largely over the last two decades. And in many jurisdictions, these predictive technologies inform policing decisions about the geographical deployment of resources, the identification of crime patterns, the location of high-risk areas, the tracking of high-risk individuals, and most simply, these are anticipatory algorithms designed to identify and prevent crime before it occurs. The use of predictive policing technologies has shifted its focus to produce forms of algorithmic governance that are legitimated by logics of accountability and transparency, and now focus on the digital trails of police. These anticipatory police algorithms are reducing complex ideas of transparency and accountability in policing and community relationships to a software that claims to be able to track the location of police officers and that can be visualized and managed through an algorithm. Early forms of predictive policing focused on the spatial and environmental crimes. They were first deployed in California and initially operated with the narrow analysis of property crime and specifically burglaries, vehicle theft, and thefts from vehicles. Subsequent versions of predictive policing technologies expanded to violent crime, but continue to focus on location of incidents. The predictive policing has now continued to evolve, and the newer iterations incorporate person-based predictions. Part of the impetus for the person-based predictive policing is the theory that a small number of people commit a disproportionate number of crimes. The person-based predictive tools, such as the algorithmically generated heat lists of the Chicago LAPD, analyze social networks along with other factors such as the criminal record history, warrant status, charges related to drugs, weapons that predict the likelihood of an individual's involvement in crime. Today, there are many companies that sell predictive policing products, including corporations such as IBM, Spot Shooter, and LexisNexis. For illustrative reasons, I'm going to focus on the most well-known and widely used location-based predictive policing product, Predpool. Predpool was founded in 2012, and it's a combination of the words predictive and policing. It sells predictive policing web applications to police agencies across the United States and in some jurisdictions in Canada. The Predpool algorithm was adapted from a technology that was used in seismology to predict the aftershocks of earthquakes, and it's based on near repeat theory, assuming that after the occurrence of a first event, the likeliness of a repeat event of the same category increases. This anticipatory police algorithm is trained on historical policing data, such as arrests, crime type, crime location, and the crime date and time to formulate predictions about when and where future crimes will occur using machine learning algorithm. Like many policing algorithms, Predpool software visually depicts future hotspots on a crime map. Now, the critics of this technology have made some really cogent points about the data harms that flow from the use of this kind of technology in criminal justice systems, and in particular by the police. For example, the scholar Ruha Benjamin has described predictive policing technologies such as Predpool as crime production algorithms, because they deploy more officers to areas deemed high risk and where they're likely to stop and arrest people, particularly the ones that are already being marginalized. However, in the aftermath of George Floyd and many other tragic high-profile incidents that vividly demonstrated racial injustice and inequality in policing, as well as in other sectors of the criminal justice system, there's now a renewed demand for more accountability in policing and an end to racial discrimination. And we can only hope that this will become a reality. However, incidentally, in the wake of this, we've seen in the last few years, several police departments have moved away from predictive policing technology, including both the Santa Cruz and Los Angeles police departments. Predpool itself, their company blog post, also references the murder of George Floyd. It argues that the collection of data and its use is integral to the transformation of police and community relations. Predpool also states that data provides transparency in decision-making. It provides audibility of decisions, and it allows all sides to be part of the discussion using the same tools and logics. This argument reflects a deeply entrenched adherence to the idea of data neutrality, which underpins the logic of algorithms. As will be discussed below, the data produced by the police and other criminal justice agencies often reflect organizational police practices. The technology developers have responded to sort of the crisis in policing post-George Floyd in a variety of ways. There's been renewed calls for police reform and mounting criticisms at the predictive algorithm itself and its use in the criminal justice system. Consequently, Predpool has rebranded its product. Predpool has shifted from a focus on predictive policing to police management, officer oversight, and also incorporates the language of ethical algorithms to perpetuate the organizational logics of the police. This year, Predpool rebranded itself as Geolytica, joining two words, geographical and analytical. Geolytical's new predictive policing technologies are marketed as offering unbiased, data-driven mechanisms to monitor police practices. This software is used to anticipate concerns about police misconduct and track the location of police. And in explaining its decision to rebrand, the company notes that the term predictive policing, which was the basis of Predpole's name, has come to encompass a wide range of activities, including facial recognition software, person-based predictions, and other things that the company no longer wants to be associated. Notably, this transition was at least in part led by the customers of Predpole, the police. Now, central to Geolytical's rebranding is a positioning of its technology as a tool for police oversight. Geolytical organizes the main page of its website according to 3 headings: efficiency, transparency, and accountability. They argue that police need to adhere to an elevated level of transparency to maintain the public's trust. To facilitate this trust and transparency, Geolytical says that the outputs of their software can be shared with the public. And even though many police departments were quite covert in their initial adoption of Predpole, we can now see that there are new technologies that are being available that are worth broadcasting. For example, the transparency that Predpole or that Geolytical is meant to offer includes patrol heat maps, which display the amount of time an officer is spending in a particular location, breadcrumb trail maps that make it possible to track the officer's movement over the course of a shift, and resource hotspot analysis highlighting the geographical locations where officers are concentrating their time, and finally, mission reporting, which is a function that shows the types of crime that officers are focused on. Now, increasingly, justice critics calling for the establishment of ethical algorithms, such as organizations for fairness, accountability, and transparency in machine learning, or FAT-ML, have looked at this incarnation of Geolytical. And it says that it appropriates and incorporates logic and language that is used to criticize the police department and the so-called algorithms of oppression. Geolytical's brand exemplifies a form of ethics washing. It incorporates language of critique without a connection to a legislative framework or to audible outputs, and also claims to produce centers of transparency, accountability, and effectiveness. Advanced forms of algorithmic governance that use machine learning and AI can produce technologies for accountability. However, some skepticism is warranted when the technology is developed and deployed in a manner that fails to step back and reflect on the problem to be resolved and the layers of solutions on top of that problem. Despite its rebrand, Geolytical continues to offer location-based predictive policing. Concerns remain that this technology is still being used to disproportionately over-police marginalized community and further straining the ties between the community and police. However, Geolytical now advertises the product as a tool for improving the police and community ties by reducing crime and allowing officers to spend more time proactively working with the community. It's important to note that while I'm focusing on Predpole as an example, in this paper, it's not the only predictive policing company to be incorporating a language of ethical algorithms and pivoting to police oversight and management. A similar use of the terms can be found in the promotional materials of other predictive software, such as ShotSpotter and HunchLab. The transition from Predpole to Geolytica does not shift the relationship between the police and those who are targeted for enhanced policing. And the pivot does not represent a challenge to existing relations of power. Instead, these algorithmic technologies reinforce pre-existing relations of power and make criticisms more challenging. Predpole's rebranding provides important insights into how technology companies are responding to political climates. Although the new focus is on police management, the company continues to adhere to claims that AI and data-driven actions will improve oversight, increase fairness, and reduce bias, as well as optimize decision-making. Geolytical's framing of transparency, accountability, and efficiency in terms of digital tracking of movement of officers is an example of how new technologies make inequalities and data harms transparent while nonetheless still black boxing and reproducing them in solutions. Notwithstanding such claims, this branded form of algorithmic accountability continues to simultaneously police the same communities as it did before. So if I move to the second example, here I want to focus a little bit more on risk assessment. Now, Ernest Burgess created an actuarial model designed to predict recidivism outcomes for people on parole in the 1920s. And various forms of actuarial, psychologically informed risk assessments have been used to predict and classify risk throughout the criminal justice system since then. As the use of these technologies and their underlying logics became pervasive, scholars engaged the terms new penology or actuarial justice to describe them. Today, many aspects of actuarial justice are being recharacterized as algorithmic governance. And with the advent of machine learning, prediction is being reframed as forecasting. The terminology is perhaps unsurprisingly muddy. So my focus here is on the introduction of machine learning informed technologies, which are being categorized as solutions to the problems identified in pre-existing psychologically informed algorithms, including the psychometric tools that are used in bail, sentencing, corrections, and parole. Both actuarial justice and algorithmic governance emphasize the use of mathematical models to predict and classify risk. Both represent a form of anticipatory governance that seeks to prevent crime. And in this example, I argue that the forms of algorithmic risk governance are shifting and assembling with machine learning technologies. Risk assessment technologies, as many of you will already know, have been extensively critiqued. Many researchers have demonstrated that these risk-based assessments further entrench systemic discrimination along the lines of racial, gender, and class lines. They are characterized, as I noted in the introduction, as algorithms of oppression and weapons of mass destruction. The concept of algorithmic bias in risk assessment has received a lot of attention following Nguyen's argument that the COMPAS risk assessment algorithm is unreliable and results in biased outcomes that overclassify Black versus white defendants. Subsequently, the enthusiasm for algorithmic risk assessments has waned, and it's waned considerably among academics, journalists, and the public are now all questioning if it can actually be ethically used. In 2020, the Pretrial Justice Institute stated, "We now see that pretrial risk assessments designed to predict individuals' appearance in court without a new arrest can no longer be part of the solution for building equitable pretrial justice systems." They also further elaborated on the fact that regardless of the science, brand, or age, these tools are derived from data used in reflecting structural racism and institutional inequality that impact our court and law enforcement practices. Use of the data then deepens inequality. Similarly, other civil liberty groups and social justice advocates have argued that algorithmic risk assessments have no place in the criminal justice system. Now, others, however, have continued to support the use of risk assessment by focusing on how they can be ethically used. Notwithstanding the prolific criticism of the tools designed to predict recidivism, there's a demand for ethical predictive tools. The criticisms of psychology-informed tools are now being used to legitimate and justify the production of machine learning models for recidivism prediction. Experts are conducting research on how to use algorithmic technologies that blend the forecasting capacities of machine learning with conventional regressions to improve prediction accuracy. Machine learning techniques are sophisticated, and frankly, they're often quite difficult to understand if you're not familiar with computer science or software engineering. But I will say I have to thank Google because it is helpful in understanding them. But as I've argued elsewhere, these new technologies are being produced by new players in the risk arena. A number of folks are increasingly working with psychologists to improve prediction tools like the level of service inventory, which is one of the most used psychologically informed risk assessments. And today, by using machine learning, they have argued that they can make small improvements in the predictive accuracy of the risk assessment tool. However, these improvements occur when there's more emphasis placed on very well-established and known static risk factors, such as criminal history, and criteria that actually are not normally used in risk assessment instruments, such as postal codes and the number of tattoos on someone's body. Other scholars are using methods such as regression kernels to forecast the failures to appear in court, arguing that this kind of machine learning is more accurate than conventional logistic regressions. And yet others use random forest models that will learn, they're smart, from the outputs of complex decision trees to differentiate and predict behavior of individual parolees. In short, the traditional correctional risk logics are merging with machine learning and technologies and rationalities that are adherent to them. There is a tendency to assume that these more accurate tools produce greater fairness and less bias. However, these predictions or forecasts are not benign. They produce an abstracted, probabilistic digital subject that is transposed onto a person who is governed in accordance with their digital proxy. Now, clearly the capacity of machine learning is significant and substantial. That said, the questions queried of it could change. For example, a focus could instead be on exploring the structural impediments that prevent people from desisting from crime, such as onerous release conditions, colonial legacies, racial segregation, poverty, lack of access to education, or barriers to housing, employment, or social assistance. I now want to move to my final example, or third example, to show how algorithms are mapping on to existing legal practices and raising some interesting ethical questions. Oops. Just want to get this back. Just bear with me for a minute here. I'm going to have to get myself back to where I was. I have too much of a trigger finger here. That put me very quickly into go. Okay, there we go. So here, I want to look a little bit more closely at some of the areas of law that are being intersecting with AI and machine learning. And in particular here, I want to look at one type of technology company, which is LexisNexis. LexisNexis is a global company that positions itself as a global leader in advancing the rule of law. It's a legal software company that is known for offering a range of legal, professional, and risk solutions. They corporately position themselves as, I quote, advancing the rule of law around the world. Ironically, they claim that for the rule of law to be effective, there must be equality under law, transparency of law, and an independent judiciary and access to legal remedy. They purport to be concerned about the 57% of the world's population that lives outside the shelter of law, which is about 5 billion people struggling for basic human rights. Today, many lawyers and law firms are incorporating big data and AI technologies into their workflow. Beginning in the mid-2000s, electronic disclosures became common legal practice, and this followed by predictive coding in the form of document review technologies that were overseen by human lawyers. LexisNexis has capitalized on this, and they now say that they can deliver powerful decision tools to customers by applying machine learning, natural language processing, visualization, and artificial intelligence to their global legal database. This technology is being used to augment and streamline legal work. These technologies mine published cases and opinions to help litigators quickly uncover new insights into the judiciary, to craft tailored arguments for the court, and to better understand past behaviors of opposing counsel. They are meant to reduce legal uncertainties and produce predictable and the unpredictability of judicial decisions. These products capitalize on judicial disparity. Drawing on academic law libraries and case repositories, they offer technologically mediated judge shopping by helping lawyers tailor their submissions to the preferences of the judge presiding over the case. This product also offers information related to opposing counsel and their law firm, all at the same time as globally advancing the rule of law. Although these technologies are currently marketed to lawyers in the areas of employment and tax law, as well as litigation, as these new applications become normalized, they will expand into criminal law. Now I want to turn to my last point, which is about how people are responding to the concerns of bias and inequality in innovative technologies. These responses are both public and private. As technology grows, intensifies, and gets incorporated into more and more processes within the criminal justice system, there has been a concern about the ethics of those practices. And recently, the European Commission for the Efficiency of Justice has created an ethical charter on the use of artificial intelligence in judicial systems and their environment. Principle 2 of this charter is non-discrimination, to specifically prevent the development and the intensification of any discrimination between individuals or groups of individuals. They acknowledge that the processing methods of the tools reveal existing discrimination through grouping or classifying data related to individuals or groups of individuals. Consequently, they state that public and private stakeholders must ensure methods do not reproduce or aggravate discrimination, and they do not lead to deterministic analyses or use. They further argue that particular care must be taken in both the development and deployment phases, especially when processing directly or indirectly sensitive data. When discrimination is identified, consideration is expected to be given to a corrective measure to limit, if possible, or neutralize the risk and raise awareness among stakeholders or consumers of the product. Nonetheless, they will also argue that machine learning and multidisciplinary scientific analysis to combat discrimination should be encouraged. The entrepreneurial private sector has also responded to concerns about the use of algorithmic risk assessments. Technology industries are now employing something called ethics leaders. Ethics leaders are specifically tasked with evaluating the ethical properties of technology. And in some cases, rather than having this position in-house, technologists contract out to third parties to test the tools for bias and to make decisions about discrimination and risk more apparent. Using the principle of no detriment, ethics leaders ensure that technology solutions are free from bias and are ethical. All technology companies are engaged with legal and criminal justice sectors are considering the ethics of their products. Evaluations made by ethics leader enable companies to actively market their tools using the language of ethical algorithms. There are several companies that market their services to test for bias within algorithms to certify them as ethical, unbiased, and transparent. Evaluations of these algorithms are like the reliability and probability testing that may have occurred in the development of other tools. Oversight and accountability mechanisms for the development and deployment of AI technologies in the legal sphere are very unevenly distributed, and they often lag the technological development. Some outside critics persuasively have argued that some technologies are inherently harmful, and in fact, they will never be applicable. And tech companies themselves are actually not currently organized in ways that will allow them to even ask, let alone answer, the question of whether or not the products and services they build are harmful. Some critical data scholars have characterized these unproven and undervaluated practices as ethics washing. So in conclusion, algorithms, as we all know, will remain for some considerable time. And with the advancements in machine learning, they will become more sophisticated criminal justice and legal partners. Algorithms, however, are not simple enactments of human intent. There is a resounding demand to produce new responsive strategies for accountability, equity, and transparency. And at this historical moment, these legal and technical sectors need to continue to publicly grapple with the long-standing problems of inequality, which is deeply rooted in the fabric and rationalities and technologies of governing crime. I have used a couple examples to demonstrate how forms of algorithmic governance have responded with the promise of reconfiguring the responsibility of the state, transparency, and accountability without fundamentally challenging underlying relations of power. By studying AI technologies that are assembled with specific rationalities, we can start to facilitate, in my view, a deeper understanding of the flexibility of emergent forms of algorithmic governance. I'll just end with this quote. Oh, actually, I won't end with that quote. Yeah, I'll end with this quote that is here, that AI technologies hold great promise in advancing society and addressing existing problems. However, the potential benefits must not obscure the potential perils of these technologies. These perils have nothing to do with killer robots or the coming of robot overlords. Instead, they will be found in the everyday structuring potentials of AI that will benefit some members of society, but leave others behind. Thank you.
Thank you. Thank you very much, Kelly. I feel myself like I'm reeling with an enormous amount of information and ideas and thinking about their implications in the Australian context. Members of the audience, we'll have some time for questions at this stage in the event. If you'd like to post a question in the chat, you're very welcome to. If you'd like to have the floor and address the audience, you're very welcome to do so as well. As audience members are giving some thought, Kelly, to questions they might like to pose, I wanted to go back to an observation you made towards the end of your example 2. And I guess many of us who come to this topic with, and I'll speak for myself, relative ignorance about the technology, but concern about the capacity for reinforcement of existing patterns of marginalization and punitive experiences for particular populations and communities. There was something you said towards the end of your discussion of example 2 about machine learning and risk assessment, which I wonder whether you could elaborate on, and that is, do you genuinely think there is potential for data that is more meaningful and useful in terms of and less regressive, if you like, to be incorporated into machine learning exercises? That is, is there potential for these exercises to be undertaken in a way which is alert to, for example, systematic and institutional racism and disadvantage?
I want to say yes and no. So I think about 4 years ago, I would have most definitively said no. Learning more about the ways in which a number of computer scientists and scholars are trying to develop technologies that grapple with these issues, I can see that there is potential for some things that can come from machine learning being integrated into the system. However, not if we keep asking the same question. So if we keep asking the same question about how do we predict which person will recidivate, will they be violent or non-violent, and within what time frame post-released, or who do we incarcerate versus who we don't incarcerate based on a set of individual and historic factors about that person and random variables that are like postal code and things that are pulled from other data sets, I think we'll just reproduce the same thing. But if you change the question to say, what are the structural impediments of desistance, then perhaps we start to look at the location of services, we look at areas where there's more help that's needed in terms of housing, employment, and other kinds of things. Maybe we start to learn that the types of conditions that judges put onto parole or probation orders or bail orders, in fact, produce recidivism because they're just basically can't be adhered to. So I think there are things that can be done. There can be, some algorithms through various techniques could look at issues around judicial disparity. They could also look at, a variety of things that might potentially happen or could happen that we haven't yet thought about. So I'm not completely pessimistic because I've seen some people try to grapple with these issues and try to expose the problem like Compass, the Predictive Compass did. But I'm also not optimistic that the solution easily lay within them, especially if we don't change the questions, which I think is, partly why I need to talk, the way I did, which is the questions have to change. And if the questions don't change, the answers are unlikely to change.
Thank you. Now, a couple of questions from the audience. I'll read them for you, Kelly, so that you need not kind of scroll through the chat. Question from Rose. With all the various parties involved in AI, tech creators, company users, individual users, and dare I perhaps add government as well as other entities, the question is there any one place responsibility should particularly fall?
Yeah, that's difficult. I think responsibility has to be distributed as well as accountability to both the development of knowing the sort of data harms that can be produced through the technology that you're developing and marketing, but also the adopters of those technologies have a certain level of accountability that they ought to, and standards that they ought to be meeting. So I think that when public institutions such as the judiciary or the police or corrections start to use these technologies, purchase these technologies, and argue that they're making for more accountable and transparent outputs, then we need to actually be looking at that and thinking about that from a critical standpoint. So, I think it's diffuse in terms of where it goes. What I would like to see is more interdisciplinary engagement with people who are querying different kinds of questions, because I think there's a lot of folks in technology who are approaching these questions with a genuine interest to develop solutions. And knowing that the technology that they are familiar with can offer solutions, but they have not yet determined how to think about the question in a different way, nor do they have the depth and breadth of the knowledge that's necessary to come at a question like recidivism or police accountability or police community relations and racialized communities.
Thank you. Question from Diana Johns. Kelly, do you think there is any potential for the role of ethics leaders working with the principle of no detriment to be occupied by people and communities most affected by the correctional, legal, criminal justice algorithmic practices, assuming they are not currently?
Yeah, I don't think they are currently. I think these are people that are employed in Silicon Valley for the most part. And people are just starting to understand and think about the concept of ethic leaders. But yeah, I absolutely do, because I think people who experience forms of discrimination, harassment, and inequitable treatment in the justice system, have a lot of knowledge. And if they're willing to share that knowledge to sort of for the betterment or the improvement of the situation, then they ought to be listened to, and that they ought to be worked with to the extent that they can be. So that is, I think, part of the point that I'm trying to put out is, and part of the point of the term ethics washing. Like if you just put people in there who check out the technology but don't know what to look for. If I'm looking at your car to figure out if it's good and it's going to work, you're probably in a lot of trouble. You'd likely want somebody who has some mechanical knowledge to look at that car, right? And so these individuals who are concerned and seized with looking at ethics of these applications need to have much more of a detailed, substantive knowledge of their impact, their history, and how they're going to be used, and what patterns have happened as a consequence of use.
Those observations lead very nicely to the next question from Vicky Santas, which is, given the way that algorithmic governance is being ethically washed, as you put it, and perfected and embedded, what are your reflections, Kelly, on how we as activists and scholars can find levers to undo these regimes in the criminal justice system and work against reforms that embed?
Yeah, I think part of it is learning about it. As I said at the top of the talk, I know less about predictive policing and legal software technologies, although I'm starting to learn a bit more about the legal software. But knowing risk assessment, understanding risk assessment, as you watch to see what's happening in the risk assessment arena for recidivism, I think part of what's really important is to start to challenge that, to write about it, to talk about it, to engage in public discourse about, what in fact are these technologies offering. And part of it is, I think it's incumbent upon technology companies and others to explain what is happening within the algorithm and how it's being used, how it's being developed, how it's different. If it's purporting to eliminate bias, then I would start to challenge the data that is being used. If you're still using the same data that is collected through criminal justice system, you're already starting off on a bad foot, because we already know that there's a lot of bias embedded within that data. So I think in terms of activism, it's important to watch to what's happening, to know what's happening, and to engage in that kind of public dialogue. And there's also there's a number of scholars who are working in the technology fields, such as computer engineering or software engineering, or those fields, who are also coming at these things with very principled positions. And I think we can't forget that as well. So we don't have to understand everything about different methodologies that are being used, but others do. And I think partnering with them to understand these things is really critical.
Thank you. Question from Andy Kaladelphos, who thanks you for the presentation, Kelly. Can you tell us a bit more about the LexisNexis example? Perhaps your reflections on the implications for criminal law, and perhaps I would add criminal courts and their operation. Is there any potential for positive implications? Just to add a coda, it does sound like, it sounds disturbing from my point of view, and I guess from Andy's as well. Yeah.
Well, it's ironically, I have seen a lot of it work in the employment context in terms of being able to look through like case law and when you would settle an employment situation if somebody had been fired. But there are some actually really interesting things that can be done with it. In the criminal law, it may make the work of public defenders or defense attorneys more effective, more critical. We know how overloaded people are in the courts and their ability to represent people well. So this may actually help or assist them, particularly as they wade through, piles and piles of precedent and case law. I think it will change the work of an articling student because it effectively does some of the work of an articling student. I also think that there are applications that are, on the periphery of criminal law. So some of the civil and administrative law applications, for example, in housing. Some places in BC have acknowledged that many people can't access information easy about landlord and tenant acts. So they've created algorithms that can be apps on phones where people can query questions about landlord and tenancy acts and say, I've got this problem with my landlord, can he really kick me out in the winter? And then some kind of bot will actually be able to help them facilitate an answer to it. So it could bring access to justice, access of the law to people, but that also presumes people have the technology and can engage with that technology and know what to search and how to search it. So I think there are things that can work well for it. If you're able to match up like LexisNexis does through natural language processing, some of the things that are said on the bench by the judiciary or codified in jurisprudence, maybe it makes more transparent bad decisions. Make it more transparent judicial decisions that are inconsistent with what we would expect them to be. So there's some oversight things that could happen. Again, it depends on who's using the technology and to what end, right? But all those possibilities are there. What scares me is that it makes really good judge shopping and just kind of, takes that practice, which is problematic, and basically codifies it.
Thanks, Kelly. Look, our final contribution in the chat is not expressed as a question, but it's a great comment that I'll ask you to respond to, Kelly, and then we'll bring things to a close. From Kimberly Dean, humans undertake their own risk assessments in everyday and in all working contexts, including law and justice decision-making. The overlap between factors that indicate risk as well as reflecting disadvantage need not and did not arise with algorithms and AI. Judges, police, etc. have always been making decisions based on these biases. The question is really whether algorithms are less biased than we are and whether the approach should move from prediction of poor outcomes to approaches focused on improving them.
Yeah, I think I don't disagree with any of that. And I do think that you can shift to improving them. But the question, I would go back to say, to answer what question. So I would not be too keen on an algorithm that is, suggesting that it can better predict recidivism using some of the factors that already embed bias. And you see people grappling with that. And once they start stripping out variables that are proxies for race and social economic status and things, you're not left with a whole lot. You're pretty much left with age, right? So I think that it depends on what the question is that we're being asked, and it depends on how it's going to be used. Like, there are things, if you're interested in navigating risk, there's some software that's like location software in some countries. And I know one in South America that is being used. It's sort of like a Waze for violent crime in areas. And it will tell you how to navigate your way home, whether you're better in the tube or whether you're better up on the street, whether you should move around a favela or go through a favela because of where the violence is at that particular moment. Those technologies can help people manage their own risk. And there's really interesting technologies around domestic violence and safety for victims and survivors of violence. So a lot of those things have really positive outputs for the quality of life of individuals, and emphasis could be put on them. And certainly refining them and making them better is not necessarily a bad thing. But again, I go back to the start. It depends on the question that you're asking. And what is the problem you're asking the algorithm to solve?
Thanks, Kelly. Thanks for your lecture and your careful reflections on the questions and comments that have been posed in the chat. Well, we're at the end of our 2021 annual lecture, but it's left to me to say a few words of thank you. They're really important at this stage. First of all, I want to thank all of you in the audience for attending this lecture. The traditional concept of the annual lecture has been in the past associated with gathering in one place, and I imagine that one day we'll return to that mode. But in the interim, the virtual world is our platform for annual lectures, and I want to thank all of the audience members for making the time, wherever you are, whatever time it is where you are, for being part of the audience today. I want to extend a warm thank you to Auntie Lola for her welcome to country. I want to extend a very warm thank you to Kelly for a really outstanding lecture, a thought-provoking lecture, one that provides multiple connection points for those of us involved in criminal justice scholarship and teaching and advocacy and activism in the Australian context. And I really think that's a major achievement that you've done that for us. So thank you. And finally, I want to extend my thanks to Tom Chapman and Tam Allenby from the Centre for Crime, Law and Justice. They have done all the work behind the scenes in bringing this annual lecture to fruition. And I extend a big thank you to both Tom and Tam. And then all that is left for me to do is to wish you a good afternoon, a good evening, and a very warm thank you. Goodbye now.